Benvenuti. Welcome to everybody. We are here for the third webinar of the European Union Law and Sustainable Development webinar series. This Jean Monnet module hosted and it's now in its third year, hosted by the University of Siena. We are incredibly lucky today to have Alessandra Donati with us, Senior Research Fellow at the Max Planck Institute Luxembourg for Procedural Law, who will be discussing the role of the precautionary principle in EU law with a series of incredibly interesting reflections on especially the recent jurisprudence of the European Court of Justice and new developments, new political developments in the EU, from the Green Deal to the implementation of the SDGs in Europe. I will first give the floor to Professor Riccardo Pavoni, the academic coordinator of the module, for some additional sort of notes on the very impressive biography of and resume of our speaker, and we'll then jump into the presentation. As usual, you will be able to type in your questions already in the chat that you see on your right on the YouTube page, and we will do our best to ask all of these questions to Alessandra towards the end. Riccardo.
Yes, thank you, Dario, for introducing this webinar. And I would like to add that this is our third webinar this year in our Jean Monnet module, and for the third time in a row we have a woman speaking today. So we are particularly, let's say, also proud about that. With regards to the problem of the gender balance in our webinar series, it does not arise. We first had Ioanna Di Gianni towards the end, at the beginning of the year, from the University of Cyprus. Last time we hosted Elena Cima from the University of Geneva, and this time we have Alessandra Donati. So we have an all-women webinar series this year, and this is particularly welcome. Alessandra Donati, as Dario was anticipating, is currently senior research at the Max Planck Institute for Procedural Law in Luxembourg. She obtained a PhD from the University of Paris, Panthéon-Sorbonne, where she also obtained an LLM in European law and French law. But I would like to mention also that Alessandra, of course, as her name suggests, is a native from my country, from Italy. So she's currently one of those Italian legal minds which is somewhere abroad, and that we hope to welcome back to the native country sooner or later. Alessandra, as Dario was, because she first graduated at Bocconi University in Milan, indeed. And as the theme of Alessandra's speech, as Dario was anticipating, is a crucial theme for our project as a whole, and for the law of sustainable development as a whole. That is the role of the precautionary principle. We are very much looking forward to hear her perspective on this topic. The precise title of her presentation is "The Precautionary Principle under EU Law, a Brake or a Lever for Sustainable Development." And as we know that Alessandra will be dealing with the jurisprudence of the Court of Justice of the European Union on the precautionary principle, and also on how the precautionary principle has been, let's say, treated in the recent normative activity of the political institutions. So, Alessandra, the floor is yours.
Thank you very much, Riccardo. Thank you, Dario, for the invitation, and thank you for allowing me presenting one topic that is really at the heart of my recent research. I'm going to share the screen with you so that you can follow me by following my slide presentation. So the topic of today, as it was anticipated, is the role and the relationship between the precautionary principle and the notion of sustainable development under EU law. To do so, after a brief introduction in which I will explain, which is the framework under which I will explain and present the precautionary principle, I will underline in the first part, which is for me the conceptual network, and you will understand the word network, of the precautionary principle under EU law, before assessing in the second part, which is the place of sustainable development within the conceptual network of the precautionary principle. So if we move to the introduction, as you all know, the precautionary principle is one of the most invoked, the most largely used principle under EU law. If you go back to 1998 with the mad cow crisis, and then you move towards more recent years with the GMO crisis, all the questions concerning pesticides, glyphosate, nanotechnologies, and even more recently, the COVID-19 crisis. In all these crises, in all these issues, the precautionary principle was involved. And it was involved because the precautionary principle is a principle that deals with risk, namely with environmental and health risk, and with scientific uncertainty. What you could say is that because the principle has been invoked in so many cases and has been at the heart of many legal discussions and case law, everything about precaution has been said. However, the more the precautionary principle is invoked and the more scholars and judges use and interpret the precautionary principle, the more the legal scope and the definition of this principle seems uncertain. As someone said, it seems that there's not one principle, one precautionary principle under EU law, but there are many precautionary principles. To underline that precaution under EU law has really many different aspects, many different applications that bring someone to consider that would be not one, but many principles. The main reason why I consider that it is so difficult to understand, to clarify, and to limit the scope of application and the definition of precaution is because precaution is a postmodern principle. Precautionary principle epitomizes the shift from a modern to a postmodern notion of law. And it is not by chance that the beginning of the precautionary principle, which is considered to be in Germany in the 70s, and then it was slowly incorporated into EU law starting from the 80s, and then more, and then in the 90s with incorporation in the Treaty of Maastricht. The precautionary principle appears in a moment in which it seems to be a progressive shift, as I said, from a modern to a postmodern notion of law. What this shift means is that law as society does not seem to be longer as a pyramid of norm, as a hierarchical order of norms where law is the only source of application, where the state is the only source of law, and where law is centered and ordered according to precise rules which have a general application. Starting from the 17th, starting from an increasing globalization, also law finds changes towards what is called a postmodern condition or a postmodern paradigm. The figure representing such postmodern law is no longer a pyramid of law, but is more a network in which different actors, state actors, private actors, public actors, private actors, but also different levels of regulation, national regulation, European regulation, but also international regulation, all these different actors, sources, and states combine and work together to create what is a network of rules which appear to be more the product of a factual interpretation than of a general application, as it was the case under postmodern law. The precautionary principle really participates to this shift, and for many reasons can be considered as the paradigmatic principle of postmodern law. As a postmodern principle, the precautionary principle has two main features. It is a flexible and it is a complex principle. A flexible principle means that, first of all, precautionary principle is a soft principle. Soft principle because if you look at the treaty article 191 of the Treaty on the Functioning of the European Union, and to all the directives and the regulations that incorporate precaution under EU law, You will not find a definition of precaution. You will find many references to the precautionary principle, but there's not a clear indication of its scope, because its content and its scope, they change according to the specific circumstances at stake. For the same reason, precaution is a soft principle, because it's very hard to sanction its breach. Until today, there's only one case, just to give you an example, in which European institutions have been sanctioned by the Court of Justice under the terms of extra-contractual responsibility for breaching the precautionary principle. In more than 1,000 cases that I examined for my PhD in where the precaution has been applied, in only one case, European institutions were sanctioned for a breach of the precautionary principle. But the precautionary principle is flexible also because it is an adaptable principle. One of the main features of precaution is that it does not impose to the European institutions the adoption of specific measures. It imposes to the European institutions to act, to anticipate the time of action to prevent a risk for the environment, public health. But again, the content of the measure is not fixed, and on the contrary, the European institutions have an obligation to change and to adapt their measures according to the evolving situation relating to the risk and uncertainty at stake, which means that the measures adopted on the basis of precautionary principle are not fixed measures, but they are provisional measures that will change and adapt according to the specific situation of the risk at stake. Flexible, the precautionary principle is also a complex principle. As it is typical of postmodern principle, precaution is a plural principle. It is a plural principle which is provided for at different levels of legislation. It is set forth, for example, by many national legislation. Just to give an example, in France, precautionary principle has a constitutional value because it's set forth by the Charte de l'Environnement, which is linked to the French constitution. A precaution is set forth in Italy, it's set forth in Luxembourg, it's set forth in Germany, in many other European countries. But it also set forth, of course, at the European level and in many different treaties and conventions at the international level. And as I said at the very beginning, if we limit our research, the scope of our analysis to EU law, you will see that precaution is applied in many different fields relating to the environment, public health. So, for example, it is applied in relation to cosmetics, drugs, food products, additives, enzymes, the protection of marine biodiversity, the use of pesticides, and so on. Because what is the very essence of precaution is that it is a negotiable principle. By a negotiated principle, I mean that precaution, of course, is a legal principle, but it is a legal principle which is applied by political decision makers. Precaution is, in this sense, a political principle which is applied, which depends on the large discretionary power which is accorded to the European decision makers. But precaution is also a scientific principle, because the condition for the application of precaution is that there has been a scientific risk assessment. So precautionary principle can be applied by decision makers only if a scientific risk assessment is made. And precaution is really the instrument which allows for a dialogue, for a negotiation between science and politics, with interference and with the mediation of law. So once I explain why, and you understand that precaution is a postmodern principle because it is a flexible and complex principle, the question arises, how can you manage such a principle? How can you deal with this principle? My answer to this question is that as a consequence of its complexity and of its flexibility, there's a need for a plural, complex, dynamic, polycentric, but ordered definition of the precautionary principle. What I mean is that when dealing with the precautionary principle, two different negative consequences or obstacles should be avoided. From one side, we should avoid looking for a clear-cut, static, linear definition of precaution, which would neglect its complex and flexible nature. Or from the other side, we should also avoid resigning our analysis to the plurality of applications, to the diversity of application, which would mean that there could not be a real legal analysis on precaution, because we could accept that precaution is only many different applications. So in between these two extremes, I think that, and it is this idea that I developed the PhD that I devoted to precautionary principle, is that we should, and actually we can look for what is a complex, dynamic, but ordered definition of the precautionary principle. It is what the French lawyer Mireille Delmas-Marty calls the pluralisme ordonné. We put together plurality and order, and we look for an ordered plurality. To do so to look for such an ordered but plural definition of the precautionary principle, what I did, and what I'm planning to do now today to you is to understand, to define the conceptual network of the precautionary principle by weaving its network. So the image of the network is typical of a postmodern principle, where different norms, as I said before, come together in this within the network. And also the use of the terms weaving, it's not by chance, because it really this textile metaphor really gives you an idea of what precaution and in general postmodern principles are. So there's these networks of different elements, of different knots, which are united with different links, the one to the other. So as you can see in the picture that I'm showing you, different links are related in the network of the precautionary principle, different knots. So if we move to the first part of the presentation, the conceptual network of the precautionary principle, keeping in mind this image, I draw the conceptual network of the precautionary principle. And the two main concepts, what I call the hubs of the precautionary principle, and I use the term hubs because these two elements, anticipation and action, are really the necessary points of passage of all the other knots, of all the other elements relied and connected within the conceptual network of the precautionary principle. So it means that the definition of precaution, for me, the definition of precaution under EU law can be built by starting by the identification of these two elements, anticipation and action, which means that for me, precaution is a principle of anticipated action. The link between, as you can see from the arrow, the link between anticipation and action is strong. I'm not gonna give in too much details on this, but what I did in my PhD is trying to define the different links, the strength, of the different links connecting one knot to the other within the conceptual network. And to do so, I made a distinction between strong links, weak links, and non-existing links. A strong link exists when according to the legal scholarship, or essentially the Court of Justice of the European Union, two elements within the conceptual networks are strongly linked, and there's a strongly correspondence between two elements. The link is being considered weak when this correspondence is not so strong, because, for example, there are different opinions by the legal scholarship, or there are few judgments that have been given by the Court of Justice. The link is non-existing when there are no sentences, there is no case law, there is no opinion given by the legal scholarship, and so two knots are not really correlated. If you go back to anticipation and action, that, as I said, are the main knots within the conceptual network of the precautionary principle, you see that the arrow connecting them is a strong one. And it is a strong one because there's a huge consensus, both in legal scholarship and in the case law of the court, saying that anticipation and action are really the main conditions for the application of precaution. So, precautionary principle entails an anticipation of the time of action, because the decision makers shall not longer wait until the risk is fully certain before adopting a measure to protect the environment and public health, but they shall act before when the risk is only uncertain. So in this sense, precaution entails an anticipation of the time of action. So an action is no longer anchored to the production of a scientific certainty, but action is anticipated to the time of scientific uncertainty. From the other end, anticipation without action would be not enough. So the decision makers have an obligation to take action to avoid the occurrence of a certain measure of a certain risk for environment and public health. However, the obligation of the decision makers is only procedural. So which means that the decision maker has the obligation to respect a certain number of procedural obligations. Now, once they've respected such procedural obligations, and for example, by procedural obligations, I mean the obligation to take into account the results of the scientific expertise, that, as we said, is the condition sine qua non for the adoption of a precautionary measure, and the obligation, moreover, to take into account all other elements, all other factors which are non-scientific factors, but could have an impact in the decision at stake, for example, social factor, economic factor, political factors. So once the decision makers have taken into account these obligations, they are free on the substantive side to decide which kind of measures they want to adopt. So taking into account the two main elements, anticipation and action, I developed in much further details all the conceptual network of the precautionary principle. Going more in details would be misleading for the purpose of this presentation, so I will stop here for the conceptual network of the precautionary principle. It was important to outline the main features of this network because the question that we are asking today is related to the place that sustainable development play in the conceptual network precautionary principle. So I can reformulate our question by asking, how is the notion of sustainable development connected to the other main notions that are included in the conceptual network of the precautionary principle? And to do so, as you all know, sustainable development, is important to recall that sustainable development is a fundamental objective of EU law. For example, just to give you an example, Article 3 of the Treaty of the European Union recalls that the Union shall work for the sustainable development of Europe, and that in its relations with the wider world, the Union shall contribute to the sustainable development of the Earth. Or again, Article 11 of the Treaty on the Function of the European Union recall again that the Union, with a view to promoting sustainable development, environmental protection shall be integrated into the definition and implementation of all the other Union's policies and activities. Taking in mind that sustainable development is a fundamental objective of EU law, can we argue that precaution is a brake or a lever to sustainable development under EU law? The question to this answer is not straightforward, because two different answers could be given. First of all, it could be argued that precautionary principle is a lever to sustainable development. If you look at the first 2001 European Strategy for Sustainable Development, as it was amended in 2009, or if you look at the 7 Action Program, which set forth the objectives of Europe from 2015 to 2020 in terms of protection of the environment, the precautionary principle is clearly indicated as a main pillar of sustainable development. Of course, as we said, precaution is a principle of anticipated action. So by anticipating, by preventing the occurrence of major risk for the environment and public health, the precautionary principle is a condition for sustainable development. Because precaution allows for a prevention of major risks that could affect the environment and public health. And in this way, it is a condition, it is a pillar for sustainable development. However, the other answer could be possible. And that is, precaution is more a brake to sustainable development. To understand this argument, I will show you 3 different kinds of omissions, which have, if we can say, characterized the precautionary principle in most recent years. First of all, in 2016, the European Commission adopted 2 different communications, which sets forth the next step for a sustainable European future, and which incorporate into EU law the new sustainable development goals. So by acknowledging the importance of the new sustainable development goals, and by acknowledging the importance of building a future for Europe, very surprisingly, the precautionary principle is neglected by the Commission. And the omission is even more surprising because the European Commission makes reference and uses the same text which was used in the previous communication, and refers explicitly to the principle of prevention and to the principle and to the polluters pay principle. So by using almost word by word the same textual reference which was incorporated into the previous communication dealing with sustainable development, the Commission makes a clear reference to the need to prevent risk, to the need to apply the polluters pay principle to sanction the conduct of polluters. There's no reference to precaution. Of course, someone could say that we're only speaking about communication, so they're not binding documents, and everything will depend on how this communication will be implemented with a series of regulations of directives which will really incorporate into EU the sustainable development goals. However, even from the political point of view, the omission of precaution seems surprising and should be understood better. And I forgot to say that there's only, I forgot to say that the second, so this was the first omission. The second significant omission is, is for the time being, at least in the European Green Deal. If you look at the communication of the Commission, which contained the so-called European Green Deal, which was issued in December 2019, and if you look at the measures that have been implemented, the sector-specific measures that have been implemented until now in relation to the EU Green Deal, for example, the proposal for a European climate law, or the communication of the Commission setting for the strategy with relation to food law, so the so-called farm to fork strategy. In all these documents in which the European Commission makes a concrete proposal and establishes the roadmap for making the European economy sustainable, there's a focus on prevention, there's a focus on anticipation, but there's not a reference, again, to the precautionary principle. And the omission is particularly significant if you consider that most of the risks that we are speaking about, so for example, climate change, are all uncertain risks. So it means that the specific effects, the time effects, the scope of climate change is still uncertain. If at the beginning of the 70s, of the 80s, it was still considered uncertain, even the link between the increasing greenhouse emissions and the impact of human activities was considered uncertain. And today we can consider that this link, at least for many aspects, is certain. What still remains uncertain is the exact extent, times, condition, and specific framework under which climate change will occur. So again, it is very surprising that all these documents that details the strategy of Europe for climate change is no reference to the precautionary principle. The only exception is a reference to precaution in relation to the protection of marine minerals in the international seabed, which is set forth in the EU biodiversity strategies. And again, I would like to ask the Commission, why is precaution invoked with relation to the protection of marine minerals and not in relation to pesticides, which are also at the heart of the biodiversity strategy? Which brings me to the third omission. The precautionary principle, as is true, as I said at the very beginning, has been invoked in many cases, and it has been at the heart of a lot of case law at the Court of Justice. However, in at least 3 of the most recent and of the most sensitive cases concerning the protection of the environment and public health, which deal with uncertain risk and which entail a long-term perspective, the precautionary principle was neglected. The first case is the case concerning glyphosate. As most of you know, glyphosate is a pesticide which is used, namely an herbicide, which is used to fight against bad crops in agriculture. Glyphosate has been put into the market in the 70s by Monsanto, and since then it has really become one of the most, if not the most widely used herbicide in the world. The use of glyphosate raises several issues from a legal and a scientific perspective, and in the last years there have been a fair divergence between, from one side, the International Research Center on Cancer, which classified glyphosate as carcinogenic for humans, and on the other side, the European Agency, the European Chemical Agency, and the European Food Safety Authority, which consider that glyphosate is not carcinogenic for humans. In 2015, the European authorization of glyphosate expired. So there was a need to decide about the renewal of the authorization for marketing glyphosate. At the end of a long proceedings in which there was a strong opposition between the Commission and different member states regarding the duration, regarding, first of all, whether or not to authorize glyphosate, and second, to which extent and to which duration glyphosate should be authorized. The European Commission finally decided in 2017 to give authorization to authorize glyphosate in Europe for further 5 years, until 2022. So the decision was made, and in the decision, what is striking to note in the decision, as many scholars have noticed, is that there's no reference to the scientific uncertainty that were surrounding the case at stake. As I said, the decision was taken exactly in the middle of the controversy between the International Research Center on Cancer and the European Agency. And in the decision of the Commission, there's no reference to the existence of such scientific divergences, and of course, there's no reference to the precautionary principle. This conclusion, this decision was attacked. Was attacked before the Court of Justice, or better, it was not the decision itself that it was attacked, which could have led to a different solution. But a question for preliminary ruling was made last year concerning in the Blaze and others case, was made to understand if the regulations on pesticide, regulation 1107 of 2009, was to understand if this regulation was compatible with the precautionary principle, and then if the 2017 decision of the Commission was in breach of the precautionary principle. However, as the Advocate General stressed, and as also the Court of Justice indirectly underlined, the real issue of compatibility is not between regulation on pesticide and precautionary principle. The issues of compatibility is between precaution and the decision of the 2017 decision of the Commission that, as I said, neglects the application of the precautionary principle. So, unfortunately, for the same ways in which the question for preliminary rulings were made to the Court of Justice, the Court could not really decide and give an opinion on the compatibility of the Commission decision of reauthorizing glyphosate and the precautionary principle. At the same time, so the controversy is going on. It seems that Monsanto is now ready to pay to execute a settlement agreement in the US, because in the US there are increasing an incredible number of cases accusing Monsanto of having deliberately put into place a product that they knew was carcinogenic. The last day, this news saying that Monsanto seems to be ready to pay for a huge amount, to execute for a huge amount a settlement agreement with Monsanto. In France and in other countries in Europe, there's an increasing number of cases concerning dealing with Monsanto. And in all these cases, one of the main legal instruments used is the precautionary principle. We will see how the situation evolves. The negotiations for the renewal of the authorization of glyphosate have already started, and we will see in 2 years which will be the source of this pesticide in Europe. Another sensitive and important case in which we can say precaution was neglected is deals with endocrine disruptors. Endocrine disruptors are, as their names say, chemical products which are largely present in the market. They are largely used in cosmetics, in food products, in household products. They are called endocrine disruptors because they have negative effects on the endocrine systems. There's not, at least until now, there's not a specific regulation about endocrine disruptors in Europe. But as far as they are linked to the use of a pesticide, they fall within the regulation that I mentioned before, which is regulation 1107 of 2009, which covers the regulation of pesticides in Europe. The most difficult task when dealing with endocrine disruptor is their definition, because they fall within a different range of sectors, as I said, from cosmetics to drugs to food to household products, and it is very difficult to define them. It's for this reason that in the regulations, the pesticide regulation, the legislators have given to the Commission a period of time until 2013, December 2013, if I'm not wrong, to provide for a definition of endocrine disruptors. This time frame, this deadline was not met. So by the time given, the European Commission did not provide for a definition, but engaged in a more than 5 years, very long impact assessment, trying to understand which were especially the economic impact of such a potential definition. In the meantime, European Commission was sanctioned by the Court of Justice for failure to adopt such a definition. The definition of endocrine disruptors was eventually adopted in 2019. And again, if you look in the two regulations, in the regulation that defines endocrine disruptors, Once again, the omitted principle is the precautionary principle. And once again, the omission is surprising because all scientific analysts agree that scientific uncertainties are really at the heart of endocrine disruptors. And because endocrine disruptors, the effects of endocrine disruptors can be seen on a long-term perspective. So it is not really the extent under the immediate effects, the immediate extent, or the immediate cumulative effects that really gives you an idea of the potential effects, but the effects can be only seen in a long-term perspective. The endocrine disruptors have namely an intergenerational perspective. So, for example, the mother by using drugs, by using cosmetics made by endocrine disruptors, can really, according to scientists, can very likely pass an infection to their babies. So, because of all these reasons, because of the existing scientific uncertainty surrounding the time effects of endocrine disruptors, the omission of precaution is once again a very surprise. The first case, and even more recent one, in which precaution has been neglected deals with the 5G regulation. As you might have heard, there's been the European Commission in 2016 has presented a new plan of technological development in Europe, and 5G is really at the heart of this new plan. So 5G, which should be implemented in many different countries in Europe, starting from Italy, Luxembourg, and France in 2020, will allow us to enter in the so-called object interconnectivity. So the 5G will allow, according to the Commission, for transport systems to be mostly automatical. So there will be a significant increase in the medical sectors, in the technological sector. So the idea is that with 5G will not only be few objects connected, but eventually every object of our daily use could be connected. The main problem related to 5G is that in correlation to environmental and health risk is that 5G will significantly increase the exposition to electromagnetic fields. So the regulation which has been adopted until today covers to some extent the exposition to electromagnetic fields. 5G will increase both the intensity of exposition and the point of exposition, because there will be much more points diffusing electromagnetic fields. So if you look at the existing regulation, which very likely will need an amendment to take into account the improving and increasing in numbers and size of the 5G, even by barely reflecting to the existing regulation, at the European level, the only document dealing with the exposition to electromagnetic fields is a recommendation issued in 1999 by the Council of Europe, in which the Council sets forth a list of recommendations for the member states to limit their exposition. But once again, the focus is only on the immediate and certain effects caused by electromagnetic fields. The immediate effects are the effects that have been studied mainly since the 70s, that are called thermic effects. So if you touch microwave, if you go next to a source of electromagnetic field, the body will suffer from an increase in its temperature. And these effects are immediate and tangible. And these are these effects which are considered by the 1991 recommendation of the Council. However, there's an increasing body of science saying that the effects of electromagnetic fields are not limited in time, and the human body could suffer from long-term effects linked to the exposure to electromagnetic fields. These effects are still uncertain, like for climate change, like for pesticides or endocrine disruptors. These effects are uncertain both in their scope in their time, in their size, but they are nonetheless possible. And there's really, will not enter in details, but there's really an increasing amount of scientific reports showing that an exposure to, for example, the Wi-Fi or your mobile phone really has the potential to increase, to provoke cancer. And the reason why the World Health Organization classified electromagnetic fields as possibly carcinogenic a few years ago. All these potential long-term effects are neglected by the recommendation of 2009, which focused on the present effects. And the same applies for the another directive, which was implemented at European level in 2013, which limits its scope of application to the exposure of employees in the workplace to electromagnetic fields. Once again, precaution is neglected. There's no reference to such long-term uncertain effects, and the focus is only on the certain verified effects on human health. So, in light of these cases, what can we conclude? Can we say, as I asked myself and as I asked to all of you, and if you have a different answer in that the precautionary principle is a brake or a lever to sustainable development in EU law? My answer to this question, but I would be very happy to hear if the public or the audience has a different point, a different view of that, is that maybe precaution is neither a lever nor a brake to the sustainable development in Europe. And that precaution, if you consider and if you go back to the conceptual network of precaution, the link between precaution and sustainable development is a weak one. So it means that if you look at the state of the art, if you look at the actual case law, if you look at the most recent legal text, the relation between precaution and sustainable development is still unclear. And the answer will be determined, very likely, will depend on how the most sensitive cases that I mentioned before, climate change, pesticide, endocrine disruptors, 5G regulation, how these cases will shape the way in which we, as citizens, but also as lawyers and at the political level, the European Commission and the other institutions will decide to shape the relation between precaution and sustainable development. I will stop here. Thank you very much for your attention, and please feel free to make me any question or comments. Thank you.
Thank you so much, Alessandra. This was a very, very interesting presentation, a lot of food for thought. I'm not sure if Riccardo wants to begin with some thoughts or reflection. I also have a couple on my end. We'll try to squeeze them in the time that we have left. Still possible for people to write their questions. I can see that there are no questions yet, but we have a good audience, so I hope that these will surface over the next few minutes. Riccardo.
No, first of all, I would like to thank Alessandra for her presentation. I think it was incredibly rich and very thoughtful. So, and this is again a demonstration that despite an enormous amount of literature that we have on the precautionary principle, we are bound to receive more and more doctrinal contributions in this area, because, of course, there's also an evolution of legal thought and perspectives in this area. I don't know, the questions and the comments would be too many here, and as Dario has said, we must try to squeeze them in order to not to abuse our remaining time. Perhaps this is just one question that I have been very curious in the past, and I'm always very curious about this. So I would like to hear Alessandra's take on this. You mentioned rightly that in your research you just came across one single case where the Court of Justice really acted upon the precautionary principle, and say, I think that you're referring to a case where a piece of EU legislation was annulled on the basis of the precautionary principle. So what are, in your opinion, what is the reason for this? Because on the other hand, we have an enormous amount of emphasis on the principle in the European Court of Justice case law. In many other cases, for example, when the Court of Justice deals with measures taken by member states, not by the EU. So I've always been curious about this aspect. What is the main reason, in your opinion, at the basis of this attitude by the Court of Justice?
Thank you for your question. The main reason, I think, from one side, we have to consider that precaution really gained attention, as you said, in the jurisprudence of the Court of Justice. So, and the Court of Justice has really made an important proceduralization of the scope of application of precaution. From the other side, when you really think specifically about the responsibility of the institutions, I think that there's a problem of proof. Because you need to apply Article 340 of the treaty, which deals with the extra-contractual responsibility. The applicant needs to prove that there was a serious and manifestly unlawful breach of a certain norm of EU law. And proving the existence of such a serious and important breach would mean going beyond the huge margin of discretion that the European institutions have. So, because the institutions really enjoy wide discretion when applied precaution, because they're most sensitive cases, which involve political, scientific issues. So it's clear the institutions are granted with a large scope of discretion, which is limited, but it's limited on the procedural side. And it is mainly limited by the duty to apply or respect a certain number of obligations, and namely the duty of care and the duty of motivations. But once these procedural obligations have been respected, on the substantive side, you can really see that it's hard for the Court of Justice to sanction the default or the excess by the decision makers to apply precaution. And the second element, always related to proof, is that to sanction the European institutions for breach of the precautionary principle, there's need to prove the existence of a damage. And by definition, when you apply precaution, there's not a damage, but there's a risk of damage. And the link between the conduct of the institutions and the existence of a damage is not certain, because it's surrounded by scientific uncertainty. So I really think that the existence of these three elements related to proof, so the difficulty to identify an unlawful conduct, the difficulty to sanction the existence of a damage, and the existence of a causal link, make the use of the extra-contractual responsibility very hard. And I think if we really want to implement precaution, we should envisage to soften the traditional requirements for the application of the extra-contractual responsibility.
Thank you very much, Alessandra. I will just show a question from the audience, and then I will add one of my questions after you answer this one. The question is from Simon, and he was wondering why the precautionary principle is actually referred to in the FTAs negotiated by the EU more frequently as a precautionary approach, and he's wondering if that makes it weaker in a way as a concept in then the implementation of the FTAs.
Thank you for this question. Actually, it's a very interesting one. I recently wrote a paper on the relation between the precautionary approach in the trade agreement between EU and Japan and the European precautionary principle. The reason why the use of approach instead of principle is not without effects or meaning. Traditionally, in the many free trade agreements executed by European Union, there's not a reference to precautionary principle, but if there's a reference, it's more a reference to the precautionary approach. In the case of Japan, the precautionary approach is mentioned in the part of the trade agreements which deals with sustainable development. And it says that the parties to the agreement, while dealing with sustainable development, shall also take into account the precautionary approach. There are several reasons why the parties, EU and Japan, decided not to refer to a precautionary principle. First of all, because Japan, in its own legislation, does not have a reference to precautionary principle. So referring to an approach is without any doubts, it's softer, it's less binding than referring to a proper precautionary principle. So, and it is more in this sense in the American tradition of referring to an approach. US, again, in the US and Canada, there's not a precautionary principle, but it's more, but the reference is made to a precautionary approach. So,
unfortunately, also the Rio Declaration, as we all know, uses precautionary approach.
Yeah, in international law, it's more often used a precautionary approach than a precautionary principle. What I think is that for sure, another aspect which is linked to that is that in the trade agreement with Japan, not only there's a reference to precautionary approach, but there's not a clear dispute settle mechanism associated with the breach of the section dealing with sustainable development. So the only dispute settle mechanism is a negotiation between the parties and referral to an expert committee. So if you take these two elements together, what comes out is, of course, less binding and more soft use of precaution. And it is clear that it is an open question, not only for the trade agreement with Japan, but also for the different trade agreements that have been executed or will be executed by Europe, the Mercosur agreement, for example, which will be the impact that such precautionary approach will play on the European precautionary principle. Will it be able to lower down the level of protection? It's difficult to answer this question. What is clear is that the legislator in all the official documents that have been adopted after the execution of the trade agreement with Japan underline that there's no issue because it is clearly stated in the FTA with Japan that each contracting parties will respect its own level of protection and will apply its own internal principles. So in principle, the European precautionary principle should not suffer from the application of the precautionary approach. However, I think it shall be seen if there will be any controversy between EU and Japan, and the precautionary approach will apply, which will be in concrete terms the impacts that could play in terms of high level, in terms of level of protection of environment and public health in Europe. So it's for sure a topic to be followed with great interest.
Thank you, Alessandra. I will just maybe sort of have one final slot. I will try to merge a couple of questions. One is sort of coming from me, and the other one we had also from Patrizia Vigni, who's, by the way, a colleague of ours, been involved in the EU Law and Sustainable Development module as well. And I will try to ask both of them together in a way, because they both refer to the international dimension as well, and the international law dimension that was being brought up earlier. On my end, what I wanted to reflect upon is the fact that, as you rightly note, the precautionary principles in many ways, at least the way in which we think of the principle today, is a reflection of complexity and sort of a very sort of atomized and differentiated interpretation of, you know, what precaution is, what risk is, which varies across time, varies across societies, it varies across different topics as well. And on the one hand, I'm wondering if the precautionary principles and the fact that it's probably that we're seeing it interpreted and applied, or maybe neglected, as you say, at the moment, has to do with the evolution of the way in which we understand sustainable development as well. It's sort of the famous sort of sustainable development snake that Professor Jorge Viñuales was talking about. The fact that we moved over time from Rio to today, from a conceptualization that had more to do maybe with conservation to something that tries to emphasize the promotion of sustainable development more broadly, if we think of sustainable development as it is articulated in the SDGs, for example, sort of a really integrated vision of how the environment fits in society and the economy and development. And the other aspect, so I'm wondering what you think about this. And the other thing is, that also in EU law, as we know, we have also, Professor Pavoni and I also wrote something about it in the context of EU biodiversity law. I think it's interesting the fact that as the principle emerged more in the context of environmental protection, it kind of took on its own way, on its own sort of different life when it was applied to public health. Because, of course, society and the legislature might see sort of the threshold, the different thresholds that should be applied and the different sort of forms of application of the principle in a different way if the values that the principle should protect are weighed differently by society or by the legislator itself. So this is why in the context of maybe GMOs, there has been sort of maybe a stricter, or in pharmaceuticals, there's been a stricter interpretation that it has been in environmental protection. So I'm wondering how, we sort of reconcile this contingency of the principle across sectors, across time, and so on. And the thing that, maybe I will ask the question from Patricia afterwards, but it also has to do a bit with this, because she was, okay, let me mention it now. She was wondering if, given this complexity and fragmentation of the concept, a more general definition of the content may be made at the international level, something that builds upon, the Rio Declaration, which by now it's, you can feel its age, maybe would help in increase the legitimacy and the recognition of the principle.
Thank you very much for all these three very interesting questions that really open the floor to the food for thoughts. Dario, to your first question, so if the neglection of precaution might be linked to the evolution of the notion of sustainable development, what I can say is that, as you said, for sure, there's an evolution in the notion, the way in which we are approaching to the notion of sustainable development. However, I don't think that I don't think that any kind of sustainable development, any definition of sustainable development that we want to adopt, even if we want to take another definition, which is no longer sustainable development as it was defined by the Brundtland Commission as this development that take together the economic, social, and economic and environmental development. So for any definition of sustainable development that we want to take, I think it's essential to refer to precaution. And precaution is such an open, flexible principle that can easily adapt to any different definition of development, of sustainable development. What is really essential for me is the approach that comes together with precaution, which means that we need to anticipate the time of action, and we need to enable to give the decision makers with an instrument to take action, even to tackle uncertain risks. And what is coming out, for example, in these recent months, is an interesting discussion between the relation between, for example, precaution and the principle of environmental non-regression. So it's not enough to say that we move towards a sustainable development. There's also need to say somewhere we are protecting our environmental acquis. And so precaution is essential, but it goes alongside together with, for example, a principle of environmental non-regression, which is invoked in some international treaties, which has been mentioned by European Parliament, which is not still set forth in any legal documents at EU law. So I think that, of course, precaution should sum up, should evolve, but because it's such finally an open principle and easily evolve and adapt to meet the needs of sustainable development. As to your second question, you are right when you say that precaution was born in environmental law and it was progressively applied in public health, with relation to public health. And actually today it's mostly with relation to public health that precaution is applied. However, and as I said at the beginning, there are differences, there are divergences in all the different cases. But however, when I looked at really all this case, more than 1,000 cases decided by the Court of Justice on precaution, I cannot say that there was really a difference concerning the field. I cannot say that I noticed that there was a difference relating to environmental and public health decision relating to precaution. there was more a tendency, a progressive tendency towards time to proceduralize the use of precaution and to scrutinize with even more intensity the conduct of public decision makers. But I did not really find any big differences. The main differences were, as Professor Pavoni said, when dealing with measures adopted by EU institutions or member states. But in that case, the main difference was not really, again, related to precaution, but was related to the kind of measures that was adopted. So it was not a measure for constructing EU law on one side, but was a measure derogating to the freedom of circulation, or, for example, on the other side. So it was, again, the kind of measures and not the principle for me which justified the differences. And on the third question, if I think that the most general definition of precautionary principle would make the discussion easier, I'm not sure that, of course, a clearer definition would help, but at the same time, if we really accept that precaution is a postmodern principle, that it changed its features, that it changed its application, that it's a soft, adaptable and complex principle, I don't think we need a broader definition. I think we should insist more on the implementation. And so, for example, going back to what I said before, I think that the implementation of precaution in EU should go alongside with a reflection on the conditions for the responsibility of the EU institutions. So if we don't change the way in which the applicants should prove the existence of a damage or the existence of a unlawful breach by the European institutions, even if precaution is defined in a clearer terms, will always be a lack in terms of capability of implementing this principle. So I would work more on the conditions for effectively and fully apply this principle.
Thank you so much, Alessandra. We are running short on time, but just as a closing maybe statement, because I find this question that we received from Daniele just now as a proper way of ending this as we kind of embark into the future with the European Green Deal, for example. What do you think will be the implementation and the impact that the principle has on the European Green Deal?
But first of all, we'll see which will be the application of the precautionary principle in the EU Green Deal. And as I said, the EU Green Deal is a pillar of sustainable development, and I really believe that precaution should be a pillar of sustainable development, and we should reflect more, trying to convert what is today a weak link of precaution in the conceptual network of precaution, or sustainable development, in the conceptual network of precaution, towards a stronger link where all the parties, both from a legislative and jurisprudence perspective, know more and are better able to implement such principles.
Super. Thank you so much, Alessandra, once again, for answering all these questions from our audience and from ourselves. Riccardo, I'm not sure if you want to offer some concluding thoughts. After that, we can close the webinar.
Yes, concluding thought, just to close the webinar, indeed, because we are always very punctual and we want to keep this tradition until the end of the research project. And I would conclude by saying that today's webinar was incredibly interesting for our research, for our projects, and for our future endeavors in this area. I think there is much work to do in this area. We should pay attention very closely to the implementing measures adopted by the EU, starting from the Green Deal, and see indeed what is the place for the precautionary principle in those measures. My humble opinion is simply that we cannot avoid, we cannot continue like this. I mean, the precautionary principle should be indeed a pillar of all the measures implementing the Green Deal. So I find, the silence of the institutions, which Alessandra has well underlined, in key areas such as 5G technology or glyphosate or endocrine disruptors, really embarrassing silence, and I hope this will be remedied in the future. So I would like to conclude by saying that we are very grateful to all the participants as well, to Patrizia Vigni, the other colleagues and students and researchers who took part in the webinars. And I would like to finally thank Alessandra for being with us. And with that, I would like to say that we hope that we will have further occasions to collaborate with you in the future.
Thank you very much. It was really nice. I think it was really nice to participate again and again. I was glad to take the word today, and I also hope there will be other chances of collaboration in the future. Thank you.
Thanks so much, Alessandra. We'll just add my own sort of thanks to what Riccardo already said. Thanks to the audience, and we will be in touch with all the followers of the Giammone module on European Union law and sustainable development for any updates in the upcoming month and a half, which separates us from essentially the end of the implementation phase of this Giammone module. Thank you again to all, and I hope that you will have a very nice continuation of your day.